So HERA, our organization, stands for Housing and Economic Rights Advocates. We're a statewide legal aid agency, and our main mission is to protect people from losing their family home, and also shield people from other financial abuse in ways we can. And so part of saving family home is the important work of estate planning, where we help people set up their plan to avoid probate or losing their home to probate. So that's how we started doing our work here. Today, we will talk about the what, who, when, why, and where surrounding the topics of estate planning. So we will be a little bit interactive and start with some true or false questions. And the animation is a little off today, so the answers are already here, but we can still try to think about these very common questions together. So some may say, I don't own anything, I then don't need estate planning. And that's actually not true. As long as we have ourselves, the estate planning process is how we handle our personal and financial matters during our lifetime and upon or after our passing. So we will discuss two main groups of documents shortly. One deals with the more traditional inheritance planning, and the other group deals with affairs during our lifetime. What will happen if we are no longer able to care for ourselves, and who can be the representative or an agent to act on our behalf? Those are some important questions, important decisions that we need to make. Some might say, I have 3 children, Omar, Oscar, and Olivia. I can leave my house to just Oscar. That's actually true. With the proper estate planning documents, there are a lot of room for customization. If we instruct so in writing, we will be able to plan according to our special circumstances. We don't have to always divide properties up equally among all the loved ones. Next one, I have a written will. My child does not need to go to probate court when I die. That's actually not true. Judge from the probate court will have to decide whether your will is valid, and then try to figure out how to follow the terms of your will. So even if you have a will, without a trust, you still can't quite avoid the probate court process, which we will discuss in more detail shortly. So my children get along so well, then I don't have to worry about anything, right? This is also a common one that people might think, but just from life experiences, or even hearing stories from other people, it's just really uncertain how our children will behave with big changes in life, and what they will think, years from now, and what changes might occur in their personal lives. So it's really hard to tell if our children, which we love dearly, will agree with each other on everything, big and small. So that's another reason why estate planning, careful estate planning on our end, will actually help ease some of these risks, and also kind of plan ourselves for these uncertainties down the line. All right, so what is estate planning? You might have heard of this fancy term before, and it's actually a process, and it mainly involves people, our loved ones, and people we trust, and property, things that we have earned, things that we treasure. And it addresses our future needs and how we want to see our properties distributed after we're no longer around. So out of all the estate planning documents, a will might be the most common or well-known one. It is part of the estate planning process, but you need more than a will to properly address all the estate planning needs that we will have in our lifetime and beyond. So estate planning documents, as I said earlier, there are two main groups, and the wills and trust documents, they live beyond our life, and they govern how we want our properties distributed after we no longer are around. And so when we are alive and healthy, we're able to make the revocable trust, a trust that can be changed or even canceled. And also we can make a will, and later on, if things change, we can make another will that cancels the previous one. So after date of death, these documents will become final. The last version of the trust becomes irrevocable, and that last version of our will be the will that stands. And there are two other documents that belongs to the different group. They're both generally known as power of attorney, POA, power of attorney for financial decision related matters, and power of attorney that deals with healthcare decisions or end of life decisions. So in California, the healthcare POA is called Advanced Healthcare Directive. You might have encountered that if you work with your hospital or health insurance on that process. So these documents, they are, we set them up when we're alive or well, and they care for a period of our time, which may never come up, where we're still around, but not able to really make sound judgments and not able to adequately care for ourselves. So those documents talk about who can act on our behalf when that happens. And those documents will become invalid after we pass away. So why would I need estate planning? So again, the main two groups that we've been talking about, one is to plan for our incapacity during our lifetime. And it's important to designate people that we trust to care for things that we really want to make sure it's done right. So our assets and also our healthcare decisions, communicating with the doctors and so forth. And then the second big reason, of course, is for post-death planning. Who among the ones we love should get what we treasure? And it, things that we have worked hard for, how do we make sure that it passed down beyond our life? It goes generations to generations, and who can manage and oversee that process? So these are all things that we need to consider, and the reasons why we need estate planning. So we will talk about the first big group, about inheritance planning, and when we're gone, what happens? What happens by law? So probate code, this law, it talks about what happens if, say, we have no estate planning done, or we have a will, then we will worry about this process called probate that's governed by the probate court. And it deals with estate that's bigger than this figure right here. Is $184,000, $184,500. It's a very specific figure. So estate is basically everything that we have by the time that we pass away, including encumbrances and debts. So say if you own a house, there's still balance on the mortgage. It's still part of the, it's still counted. It's the gross value that matters for the calculation of the probate threshold. And the date of valuation is date of death. So it's the date that we pass away, using that day to see how much that we have at that time will be worth. And if that's grossly over $184,500, then probate court will take interest. And that's basically almost everyone, especially if we are homeowners in the Bay Area, things easily exceed that amount. So we'll talk more about what probate is a little later. But here are some assets that are not subject to probate, so exceptions to the probate proceeding. The first bubble here, we see property held in the decedent's revocable trust. So that is, we will talk about it more. The trust, as I said a little bit earlier, is different from a will, where we will, if we use the trust to govern how we want our assets and treasure to be distributed, then it's a private contract, and the probate court will not take interest in properties that are placed in the trust. So that's the first one, first way that we can sort of avoid probate. A second bubble here, it talks about property or real property held in transfer on death deed. It's a very California special, I guess, product where there's an option to dispose of your real property through this device called transfer on death deed. It will look very similar to your grant deed, which is the title document to your house. The big difference will be that it names transfer on death beneficiaries. And so that after we pass away, the beneficiaries listed on this transfer on death deed will be able to take title. So that's another way to avoid probate. If you use a transfer on death deed to spell out who your beneficiaries are to your real property, then the probate court will not touch that piece of real property, and that could be left out of that court process. And then the third bubble here is bank accounts that name POD, which means pay on death. So if you have pay on death beneficiaries named in different accounts that you have with different financial institutions, the bank would, after your passing, transfer the balance to your pay on death beneficiary or beneficiaries in equal shares. And then the fourth bubble on top is if everything you have, gross value on the date of death, is less than $184,500, then it's below the probate threshold. Probate court will not deal with that estate, which, and it's possible that by the time we pass away, we have less than that, but it's usually not the case. And then the lower three bubbles here, property held by the decedent in joint tenant. So when you buy a house, you might see that language. If you buy it with your spouse, so-and-so and so-and-so, joint tenancy. So it doesn't really avoid probate altogether, but it sort of delays it. Because joint tenancy is this arrangement by law where the last person standing, the last person alive, will take all. So you can have two or more people being joint tenants on real property or even bank accounts. It's the survivors that will take all, and the last person will take 100%. So after the last person also passes away, then if it's beyond the probate threshold, then probate court will come in at that time. But until then, probate court will be left out of the process of who gets what. And the next one is property passing to surviving spouse or registered domestic partner under this code section here. It's similar idea to the joint tenant in that the last man or woman standing take all. This is just in the marital context or registered domestic partner context. And last one here, retirement or death benefit property with beneficiary designated. So similar to the bank account idea, if you have named someone or multiple people, sometimes you have the first in line and then the backup. If you have these beneficiaries clearly designated, then that will be the contractual agreement between you and the institution that handles your benefits and or owns your retirement account, and that will kind of just take care of the distribution. The court will not get involved. So these are assets not subject to probate, and also kind of ways that we can use, ways we can try to avoid having to deal with the probate court. So we'll talk about this revocable trust and talk about it from different angles. So there are some terms that you might encounter if you are in the process of working with a lawyer and creating your trust document. You see these roles like settlor, grantor, trustor, which is the same actually. They're the trust maker, the creator of the trust. And then you see trustee and beneficiary. So trustee is the role that kind of manages things according to the trust terms set up by the trust maker. And beneficiary, by definition, is the one that benefits, that will take the gift. And so it's interesting, during lifetime, when we set up this document, we are actually all three of these roles. We're our own trustor, trustee, and beneficiary. And then with that, we're able to sort of enjoy whatever properties that we own the same way we enjoyed them before. So just because we place this property into the trust doesn't mean we're giving up control over this property. So we can still feel free to sell, to buy, sell this house or buy another house and buy it into the trust, and all of that still remains the same. So you will see terms like revocable inter vivos trust, which is the same as living trust, and you see pour over will that kind of works with the trust, that tells the court that everything that I have, even if I didn't get to put them into the trust, I want them to be also governed by the trust terms. So it's a simplified or more specific kind of will, or special kind of will that you usually see that works with the trust. And then you also see these provisions that identify your family members and who the trustee and successor trustees are. So during lifetime, we're our own trustee. After we're no longer around, successor trustee then step into our shoes to be the trustee that really manages affairs according to the trust terms. And you see distribution clause, which is important. It talks about basically who receives what from what we own. And then you see there's specific gifts and there's residue. So specific gifts are a certain dollar amount or a specific property. The residue is everything else. And then TPP, it stands for tangible personal property. So you can specify to a great detail, or you can just state, oh, I only have one child, and 100% of everything I own go to that child. So it's there's a lot of room for customization again. And then you specify trustee compensation and accounting related agreements. And then spendthrift clause is a clause that both spendthrift clause and no context clause are clauses that protect the trust maker, and it's in a way shield the trust assets from the clause of your beneficiaries creditors, until your properties pass through trust to your beneficiaries, they're yours. They're not accessible to your beneficiaries creditors. So these are just ways to protect your property, and no context clause kind of protect you against future disputes over inheritance. It's a way to kind of discourage anyone challenging how you want to distribute your assets. So these are ways, specific provisions you encounter that are the more key provisions that will appear in the trust document. So comparing a little bit between having a living trust versus not. So when we don't have a living trust, as I mentioned earlier, if we say have nothing, so not even a will, or if we have a will, there will be a probate process needed. So probate is court process, basically is costly because a court process involves many steps and staff involvement and supervision and fees at different stages, so it's costly, and also it could cost long time. And with COVID, there's a backlog in the local probate court, and so that's kind of the general reason why we're trying to avoid it. But just going into a little bit more detail here, comparing the two processes. Having a living trust, then we don't have to worry about probate. Not having a living trust, and if say your estate is over that threshold that I mentioned earlier, then we have to worry about probate. And then having living trust, when no probate is needed, everything also stays private. So because living trust spins off from contract is a private document, and there's no court proceeding involved, so it's a private process how it's administered. But for will and probate process, the will becomes a public record once you enter probate, and the process also is quite public. It's available on the court system that people can check. And then with the probate, there is statutory compensation. We'll have a chart later to illustrate more, but basically the law will determine how much you need to compensate the personal representative who is appointed by the judge to kind of care or manage our affairs. And it cannot go below that compensation, which is a higher number than if we set up the trust. And then the next difference will be the executor, which is similar to a personal representative. Executor is when you have a will, the person that's managing things according to your wishes will be the executor. He or she has to do the tasks under court approval. So a lot more supervision involved and time and money. Versus successor trustee, in the living trust context, the person that steps in your shoes after you pass, he or she does all the tasks according to your trust terms without having to submit to court approval or supervision. So of course, you're still protected by law that they have to act on your best interest. They can't just act freely beyond what they're authorized to do. And then the next difference, assets in the living trust is not subject to estate recovery. So for some people at some point of their life receiving public benefits such as Medi-Cal, there might be a concern with the estate recovery, where the government looks back on the last 5 years of you receiving their benefits and try to find a way to kind of claw that benefit received or used benefit back using your properties. So if you have no living trust and your assets are subject to probate, the probate covered properties are subject to estate recovery as well. And with the current law that's effective January 2017, if you have a living trust that holds your main assets, those are shielded from the so-called estate recovery. So that's also a major difference and could be a major benefit of having a living trust if you anticipate receiving Medi-Cal. And then overall, we'll have a little calculation in the next slides, but the money that goes to your beneficiaries will be more if you go with the administration of living trust versus if you go through the probate process and what the beneficiaries have in the end will be less. So I talked a lot about trust and also briefly about will. So what is a will? Will contains your wishes and desires and big picture, who receives your assets after you die and who will manage your estate to make sure it happens. So in that sense, big picture wise, trust takes care of very similar things. But the main difference will be that with a will, without the trust, if you're over the threshold of probate threshold, then the probate process is still needed, is how the court attempts to protect the interest of the decedent, the person that passed. And the court wants to know, even if you have a will, whether it's valid or not. So that is, in a nutshell, what a will is. And what is a probate? So already, I hope I already painted, I have painted a picture so far, but it's a court supervised process for transferring a deceased person's estate to the beneficiaries named in the will. And if there's no will, well, if there is a will, probate will determine whether the will is valid or not. And if there's no will, a court will appoint a personal representative, and it could be called administer. And when there's a will, usually that person is called executor. So how do we distribute that person's properties if there is no will? There's actually probate code section that deals with that. And it kind of goes by the degree of closeness of these people to you. So it's a spouse, and then children, grandchildren, and other issue. Issue means offspring. So children's children, if there are any, and if not, there are none, then it goes to parents, and then it goes to sibling. So it's a very spell out kind of a formula of who gets what first, and then who is the next in line. And with every family circumstance being very different, this hardly can adequately address a lot of the scenarios. So in the extreme case where you don't have any of these really closely related people, it might even then eventually go to your creditors or the state or any other person. So this is sort of the kind of the error at law. And yeah, it's a very spelled out kind of a formula. Now, this is another chart that kind of shows the same idea of by law, how distribution will happen and what's the order if you don't have anything in writing yourself. So this is a chart, you don't really have to worry too much about the specifics on this chart. This is a diagram from the Alameda Probate Court website, and it just shows the, gives us a rough idea of a probate process and how it could be quite cumbersome and time consuming and kind of rigid. So you have to file this petition for probate and at some point publish notice of petition and at least 15 days prior to hearing. So it's a lot of procedural little details. and then you mail notice to persons entitled to receive notice. So anyone that's related to that person, you get a hearing date at some point, and you appear, you prepare inventory and appraisal. So yeah, it's a lot of work, and it's a long process, and every step of the way, it's a very specific step that you need to take. So it's hard to imagine going through this entire process without the help of a experienced probate attorney or professional, or anybody who's have dealt with this again and again. So this is why, if possible, we're trying to avoid this process. And I mentioned earlier, with probate, there's also statutory fees, and it's kind of calculated based on the gross value of our estate. So if, say, by the time we pass away, everything we have is around 1 million, then there's a law required fee of 23,000 that needs to go to the personal representative that the court appoints. And it's a separate sum that goes to the probate attorney that's involved. So that's a sizable amount. That is not the case if you have a trust that takes care of your inheritance planning. So there's a comparison between trust administration and probate administration using this round up number of 1 million as the fair market value of our estate by the time we pass. And even if it's a house, all we have by the time we die is a house, and it's worth 1 million, and mortgage balance 300,000. Same net value under trust or probate, 700,000, and just imagine same cost of admin, and then we have the same balance to begin with here between the trust administration and probate administration, which is this is $680,000. With trust, you can say, I want to give my trustee reasonable compensation. So the law doesn't quite require you to give a specific amount or a specific percentage. You can have the freedom to give a reasonable amount, which might be 1% of your estate. And then you don't really have to hire an attorney if your administration is quite straightforward. Say if you have one beneficiary, and the beneficiary is also the successor trustee, there's very little room for dispute. You don't really have to hire an attorney to carry out that administration work. And versus in probate scenario, there are these statutory fees required, and in the process, as I showed in the diagram, could be cumbersome, even if the family dynamics might not be complicated to begin with. The procedural requirements can still be quite burdensome, and you might need to involve an attorney. And with two sums of the statutory fee, you end up with a lot less to distribute to your loved ones, to your beneficiaries, if you have to go through the probate process. So I want to kind of illustrate the pointers that I have talked about so far by giving two short case studies. So the first one, we're looking at Pamela's estate. Pamela passed away on March 31st of 2018, and she left behind these assets: a house that's worth 300,000, probably most likely not a Bay Area house, but just I imagine that figure. And the house is dated. The house is titled to Pamela, trustee of the Pamela Trust, and the date of the transferring into the trust is Christmas of 2007. And then she also has left behind 2 IRA accounts, the retirement account worth 145,000 in total, naming Ben as the beneficiary. She has a life insurance worth 70,000 and naming her elderly mom Stella as the first beneficiary and her younger brother Leo as the second beneficiary. Stella passed away in 2016. And then it's checking and savings account having in total $2,000 in the balance and naming boyfriend Tommy as the beneficiary. So you can think whether a probate proceeding is needed for dealing with Pamela's estate. And if you feel inclined to do so, you can put your answer in the chat. And let's see if we can get it right. I'll give about 5 seconds. Okay, so far I see people saying no, mostly, and that's correct. Pamela's estate does not need probate proceeding, and the reason why is the house is titled over to the trust. The IRA account and the checking and savings account have beneficiaries named, and the life insurance, even though the first beneficiary predeceased Pamela, her second in line beneficiary then steps in and is able to receive that gift. So in these ways, she effectively avoided probate. Next, we have Alex. Alex's estate. Some similar figures here. Alex died on the same day of the different year, 2018, March 2018. He has these properties, a house worth 300,000, titled in Alex, a married man, 2 IRA accounts of 145,000 with no beneficiary designated, life insurance of 70,000, designating Sean, his father, as the first named beneficiary. There's no second named beneficiary, and Sean died in 2016. And checkings and savings account of $2,000 in total, designating girlfriend as beneficiary, but not really specifying the name. And multiple people claim to be his girlfriend. Does he or his estate need probate? Very good. I see a lot of yes in the chat. And the answer is yes, because his house is under his personal title. There's no trust that holds the house. The house is subject to probate. No beneficiary for IRA, then probate is interested in that. And life insurance naming the father, but unfortunately father predeceased him and there's no second beneficiary. And then the checking and savings account named someone, but not specified enough to know who that is. So in a way, not really having a named beneficiary. So in that case, total estate worth around $517,000 are all subject to probate. So we talked a lot about trust and the difference between a trust and the will, and the difference between trust administration versus probate administration. And as I said earlier, with that slide of that has many bubbles, there's this other way that we can utilize to avoid probate for our real property, which normally is the biggest piece of our asset. Is called transfer on death deed. So real property held in transfer on death deed, it has some requirements for eligibility. So it could not be a very large apartment complex, can't be agricultural land too large. And yeah, so there's these kind of limits around who can use this device. And usually if it's single family home, which most people have, we can use transfer on that deed. And there's also some formalities requirement. It has to be beneficiaries must be identified by name, and then it has to be signed in front of a notary and dated, and also recorded within 60 days after notarization. So that requirement is kind of strict for dating. And then also when you change your mind and want to revoke this transfer on that deed, there's also formality requirements for that. And I believe the most recent version requires both notarization and witnessing. So it's something to be on the lookout for. And it's a device usually for a very specific scenario, usually in a very urgent situation when it's kind of infeasible to create a whole trust document. Transfer on that deed could be a faster alternative to a traditional living trust in dealing with your real property and trying to shield that from probate. But then it has limitations besides the formalities and eligibility. You might have a hard time specifying two children receiving different shares, for example. That's I don't think that's something easily done through transfer on that deed. It probably it has to be equal 50-50. So there are some limitations, but it's nonetheless a way to avoid try to avoid probate. So this is an example of what transfer on that deed looks like. It's very similar for the most part to your grant deed, and you can notice in the bottom here there's a beneficiary, which is unique to transfer on that deed. Okay, so we are done talking about the documents that we need for inheritance planning to govern what happens after we're gone. During our lifetime, for incapacity planning, we talked about power of attorney for financial purposes, and also advanced healthcare directive, which is the California way to call the power of attorney for medical decisions. So these are documents during our, they govern matters during our lifetime. So this is also another reason why estate planning isn't something that's reserved for the wealthy only. As long as we have ourselves, we need to think about incapacity planning. It's an important part of our estate planning, and it allows ourselves to plan for incapacity by naming people that we trust to make necessary financial, personal, and healthcare decisions. So things like filing tax return or paying utility bills and discussing things with the doctor. It allows us to describe our desires about future care. And it could be very specific. Maybe if we're allergic to certain pain medication, we want to make sure our agents know not to use that, or discuss with the doctor not to use that. And then it also talks about organ donation, and it talks about our preferences for in-home care versus going to elderly home, and also we can give our agents power to make annual gift to reduce our estate tax burdens if that's a concern. So there are a wide range of things that we can sort of discuss and set forth in the power of attorney document. And then a main purpose of setting up these documents while we're still healthy and well is so that we don't have to worry about this other court proceeding called conservatorship. So conservatorship is needed when we don't have any of these documents set up, and it's hard to tell who can be the fit person to manage our affairs. Then the court will get involved and try to name someone. So again, that's could be costly and time consuming and not really yielding the same result that you would want had you planned. So I kind of grouped together the two kinds of incapacity planning documents together because they're similar in many ways. And this slide talks about power of attorney for financial purposes. And you will just encounter some roles again. You'll be the principal setting this up, and an agent is the one that really carries out matters for you. And it's called attorney in fact in the documents. And you can also specify how much authority you want to grant. And sometimes you only want certain things granted. You can have the freedom to do that. And for both of these documents, for incapacity planning, it's a good idea to have different people in mind. So maybe the person you trust the most can be the primary agent, and that person might not be physically the closest to you. Then you have some backups that can really act on your behalf if one reason or another your primary choice is not able to help out when the time comes. And it's also helpful, if possible, to choose someone who's assertive, who can kind of really help you communicate with these financial institutions and also healthcare providers. And it's a good idea to every 3-5 years review these documents that you have made and see if they're still current and they still represent your wishes. And it's an ongoing discussion that you will have with your loved ones to make your wishes known, both through discussion, open discussion, and written documents. The more you communicate your wishes in advance, the more the family members or your trust ones know how to care for you best. So conservatorship, briefly mentioned, if we're not able to make decisions to care for ourselves and to really even feed or dress ourselves or handle our finances, managing the recurring payments and knowing how to drive ourselves back and forth, all these things, then without having incapacity planning documents, without the power of attorneys in those two areas, the court then will be interested in appointing someone, a conservator, to manage our personal and financial affairs, and also supervise in this process of naming someone, and then also kind of help work with this conservator in making these big decisions about whether it's a good idea to stay in home care or going somewhere in a facility. So you can see how this process, it could really rip yourselves of a lot of control, and there's no guarantee whether in the end the court will appoint someone that you truly trust. So if possible, we want to have we want to proactively plan for our incapacity through using the devices that we discussed. So besides advanced healthcare directive documents, in the medical setting, there are other forms and arrangements that take care of specific areas of our care. So you might have heard or used or you've seen that in your loved ones that use the do not resuscitate form, or a post form that's a pink slip. And so these are different from your advanced healthcare directive, but they work together in many cases with your advanced healthcare directive, and you can certainly also refer to these other arrangements that you have made with the hospital in your advanced healthcare directive document. So some quick examples of that post form. The very bright color, it alerts the first responders when they try to care for someone that's very severely ill and probably have a hard time expressing his needs or her needs in the moment of emergency. And this kind of tells the first responder his or her preferences regarding care. And then do not resuscitate form that governs that specific desire. So far, we talked about the two main groups of our estate planning documents that will take care of our inheritance planning as well as our incapacity planning. When you are thinking about starting this process, or if you had done some of these documents years ago and you try to revise the document, revisit them, and perhaps revise them, you want to meet with the estate planning attorney, with your spouse if you are married, and you, in the process of discussing with the attorney, you provide your personal information and also financial information, basically who you love, who you trust, and what you have, and how you want to have them distributed. And then in the process of working with the attorney, you will review the drafts prepared by the attorney until you're satisfied, you understand the main terms and also the important provisions and how your distribution is set up, and you make sure you understand everything. After that, you want to formally sign these documents in the presence of a notary. And for will, you need to get the will witnessed instead of notarized. So there's nuances there regarding execution, but most of the documents will be signed in the presence of a notary. And once you have that signed and notarized, the documents themselves will take effect, but the process is not done. You really have to also fund the trust. The most important piece of property a lot of the times is your personal residence that the real property that you want to protect. You will work with the attorney to make sure to transfer the house from your personal title over to your trust. So you'll hold the property as so-and-so as the trustee of the so-and-so family or individual trust. And have that new grant deed recorded at the recorder's office. That's different, like, it's a similar process, no matter which county in California. And then there are some other funding related tasks to do with your other types of properties, things like your bank account and so forth. So you go through the funding process and making sure that your properties are adequately held by your trust. And that's how we can actually shield those valuable properties away from the probate proceeding. And after that process is done, we will want to make sure to review the documents periodically. You know, when life happens or life changes, when you have a new grandchild born, for example, where you want to add names to your beneficiaries, or if you decide to downsize your home, you can buy a new property directly into the trust. You just want to make sure that your documents are current and that they don't leave out important people and property. So this is just a little visual reminder to update your documents. These are some famous people that have tragically, one way or another, didn't get to update their estate planning documents before passing away. And so, for example, Barry White I believe he separated from second wife for a long time, so he had a long-term partner that he didn't marry, and the partner tried to, or the girlfriend tried to claim inheritance, but failed, and the second wife, who he had separated from like a long time ago, was able to take everything. So that's kind of the unwanted consequences of not updating our estate planning documents when life changes. So that's the end of my presentation. At HERA, we have this phone number and email address, and also our website that provides some resources that you can reach out to us by. And when you call us, you will speak to our intake admin staff, and who will then help you set up appointment with one of us on the estate planning team. Then we can work with you in setting up your estate plan or revising your documents if that's something you will need. And also you can contact other attorneys that your family or friends have worked with and had a good experience. So it's a very important next step to really think about our own decisions and our own estate planning processes. So yeah, so that I'm gonna leave this contact information up a little bit longer and try to address some of the questions in the chat here. Assets in living trust not subject to estate recovery. It's a CA specific or federal. That's a California law that was amended in 2017, not a federal law. And let's see, the next one is transfer on death deed must be recorded 60 days after signed and dated, within 60 days. So good question. Who is it recorded with? It's recorded with the county recorder's office. Let's see the question. If we have durable power of attorney, do we still need trust? The answer is yes. Durable power of attorney takes care of our incapacity planning. So things like, for example, besides paying our utility bills and tax returns, things like going to the bank and trying to withdraw some money and hire a caregiver, things of that nature. It still concerns things that happen during our lifetime. And a trust talks about inheritance planning. So after we pass away, I have, for example, 2 children. I want them to have my house equally. So that's something that the trust will trust will take care of. So they're in different arenas. So even if we have durable power of attorney, we still need a trust if what we have at the time of death is above the probate threshold. Can we use software to file trust and will and healthcare directive? There are many ways that the internet makes available for people to sort of DIY their trust documents, and certainly one way of doing estate planning. I would just advise clients who plan to do so to be careful, because some of these services might have one-size-fits-all kind of template that might not be adequately addressing your situation. Yeah, so typically it's more prudent to work with a professional and to work on this process together. But yes, there are certainly DIY options out there as well. What would the tax implication be in trust, probate, and durable power of attorney in finance matters? Tax implications. So having a revocable trust doesn't really protect us in a tax, from a tax perspective. I'm not going to go into a lot of detail in tax implications because I don't focus on tax. I don't practice tax law myself, but it's if you might have heard of irrevocable trust, which helps reduce taxable amount or estate taxable amount. But estate tax threshold currently is very high. Most of us don't need to worry about that. It's somewhere around 12 million for the estate side. So other than that, our income tax and other taxes, having our revocable trust doesn't really give us additional tax protections. It mainly helps with avoiding probate. The next question, how much does it usually cost with HERA to file these documents? I would say preparing these documents, because we're not really filing these documents. These documents mostly are private. They don't need to be filed, with the exception of grant deed that needs to be recorded. So at HERA, we have a sliding scale that kind of asks you for your household income level. And based on that information, we have a sliding scale of legal fees. In some circumstances, when the income is very low, we will offer free legal services. And the next one, a similar question, cost of getting the documents in place. Other than spending time on this, why would one not, other than spending time on this, why would one not want to have a trust? I can imagine for people who don't own a home, they can try to use some of the other probate avoidance devices to accomplish avoiding probate, such as naming beneficiaries on your accounts and so forth. And but if you do have a house, well, even if you have a house, like I said, in some urgent situation, you might use the transfer on death deed to take care of it instead of a trust. But most of the time, trust will still be a best option. Where do we obtain the transfer on deed form? And once the transfer on deed is filed, will it complicate the mortgage refinancing process? Transfer on death deed has templates on the internet, and it's searchable, and you just have to make sure to look for the newest version and kind of have to dig around a little bit to see which one is the newest version. And complicating with the mortgage refinancing process, nothing that I've heard of or know, but I'm not 100% sure. And that's something to bring up to your mortgage servicer. Describe our organization, nonprofit or regular law firm. We are a nonprofit, but it functions similar to a law firm. We have staff attorneys and senior staff attorney and also admin staff. So it's similar to a law firm where we produce lawyerly documents. And it's different in that we are nonprofit, so we are mainly funded not by money paid by the client, but government and other agencies and are able to carry out these programs by working with these sources of funding. So in that sense, it's different. Difference between TL transfer on death deed and holding home as community property with rights of survivorship. So if you hold property in community property with rights of survivorship, it's very similar to a joint tenancy arrangement where multiple people have the property and the last person standing will have everything. And so that's community property with rights of survivorship is in the marital context. So husband and wife holding property with rights of survivorship. So the survivor of the two will have 100%. So that's that. Transfer on deed, that deed is completely different, where you are essentially having a separate deed, And this deed is not the title document, but it talks about how do I want my house distributed after I'm no longer around. So it has beneficiary designation, and the recording, requirements are a little different. So they're very different. These two things are two separate ways to avoid/delay probate. Can properties outside the US be included in the trust executed in California? Properties outside the US, it's a big question. It depends. So for real properties, usually how they are distributed and governed will have to deal with the local law. So a house in Hong Kong, it might have to really look into the local law in Hong Kong in determining how that piece of property is distributed after the house owner passes away. So it depends. That's my short, lawyerly answer to that question. And I believe that's the end of the questions here, unless there are additional interest in addressing more questions.
Thank you, Irene and Alan, for being here today. It was an excellent presentation. Of course, the library doesn't endorse any one organization. Thank you for explaining that you're a nonprofit. And thanks to you all for attending.